60 years after Bolling versus Sharpe, Public Education and the D.C. Federal Courts is a program planned and developed by the Historical Society of the District of Columbia Circuit on June 19, 2014. Setting the stage is Eloise Pasachoff, Associate Professor at Georgetown University Law Center, teaching and writing about education law. Moderating the program is James Forman, Jr., Clinical Professor at Yale Law School and co-founder of the Maya Angelou Public Charter School and member of its Board of Directors. Panelists are Roderick V.O. Boggs, Executive Director, Washington Lawyers Committee for Civil Rights and Urban Affairs, and founder in 1980 of Parents United for the D.C. Public Schools. Kaya Henderson, Chancellor, D.C. Public Schools, and formerly the Deputy Chancellor of the D.C. Public Schools. Brian Jones, Senior Vice President and General Counsel of Strayer University, former Chair of the D.C. Public Charter School Board and General Counsel, U.S. Department of Education, from 2001 to 2005. And Judge David S. Tatel of the U.S. Court of Appeals for the D.C. Circuit, former Director, Office of Civil Rights, U.S. Department of Health, Education, and Welfare, 1977 to 1979. And now, an opening note from Stephen J. Pollack, President of the Historical Society of the District of Columbia Circuit.
Good afternoon. Welcome, everybody. I'm Steve Pollack. I'm President of the Historical Society of the D.C. Circuit. We're delighted to present to you this program, 60 years after Bolling v. Sharpe, Public Education in the D.C. Federal Courts. I'm introducing to you Associate Professor of Law, Eloise Pasachoff. She's at the Georgetown University Law Center. She teaches and writes about education law. She's a former teacher. She's a parent of a student in the D.C. public schools, so she's touched all the bases. She's going to set our stage for the panel, looking at the history, presenting to you the history of the engagement of the D.C. federal courts with the D.C. public schools over the last 50, 60 years. Professor Pasachoff, the microphone is yours.
Thank you. Thank you for that introduction, Steve, and hello, and thank you all for coming to this very exciting panel on 60 years after Bolling versus Sharpe. So when Steve and Jeff Kleinberg first asked me to do this historical introduction, the tentative subtitle that they gave me for the panel was this: the role of the D.C. Circuit Courts in ensuring the success of public education in the District of Columbia. So I have to say that as a professor of education law, that subtitle struck me as a little ambitious in terms of its expectations for the role of the federal court. So I thought about going back to them and suggesting that they put a question mark at the end. So the role of the federal courts in promoting the success and so on. I didn't do it, but as it happens, they changed the subtitle themselves. So the subtitle for today's panel is now called much more generally Public Education and the D.C. Federal Courts, without any affirmative claims on the court's role in ensuring success in schools. So I think then that means we can actually legitimately open up this question for interrogation today. Have the courts played a role in ensuring the success in public education in the district? If so, in what ways? And if not, why not? So by way of opening up this inquiry before, in my role of setting the stage for this illustrious panel, I'm going to do three things. So first, I'm going to give you some basic facts about the ways that the courts have been involved in D.C. schools over the last century or so. Second, I want to talk a little bit about some competing narratives that we might see these basic facts in. And then third, finally, I'll step back and just ask what we might make of all of this. Okay, so first, some basic facts about the way the courts have been involved in D.C. over time. And in order to do this, let me begin by saying something about the way the schools were organized from the very beginning of the city, of the district, back in the 19th century. So almost immediately after the district was chartered in 1802, a public school system came into existence, but it was for white students only. And eventually, because of financial difficulties, it became for poor white students only. Now, there was a black school system, but it was entirely privately run, started by former slaves and supported by private contributions, not by tax dollars. In 1862, Congress passed a law. Remember, Congress is still controlling most of the district's business at this point. Congress passed a law mandating that all children in the district, black and white, between the ages of 6 and 14, receive some small amount of public education, but the structure of funding and the structure of governance for black and white schools remained entirely separate. Now, in 1906, after lots of conflict about the running of the public schools, Congress set up a 9-member board of education, and to ensure the independence of the board's members, made the judges in the DC District Court appoint the board members. Now, as a legal matter, this raises all sorts of fascinating separation of powers questions that I hope your issue-spotting hats are starting to notice. But notwithstanding these complexities, this was an arrangement that lasted until 1968. So you can see how during the rise and flowering of the civil rights movement, because of this appointment power, the DC courts were involved in quite political questions about the running of the DC public schools. All right, now aside from these very untraditional involvement of the district court in the public school system, of course the federal courts have been involved in much more traditional Article III ways through the resolution of cases and controversies. So now let me introduce a couple of, I'm going to just tell you about 5 different categories of such cases that the federal courts have been confronted with over time. So one such category is a series of desegregation cases. So in 1950, the federal court in DC actually said that separate was perfectly equal, that evidence of overcrowding in black schools and empty space in white schools, and of shortened days and double shifts in black schools and regular length days with only one set of students in white schools wasn't evidence of inequality at all. Now, on the strength of this decision, which was called Carr versus Corning, the district court in other cases went on to affirm segregation on public playgrounds, reaffirm segregation in the schools in its own decision from the bench in Bolling versus Sharpe, which was so obvious to the court that it didn't even merit a written opinion. And while the court did make the District of Columbia Public Schools bring back black deaf children from Maryland, where the district had been sending them to be educated, bring them back into the district, it did affirm, in fact mandate, the separation of black deaf children and white deaf children in the only school in DC that served deaf children at all. So that's one set of cases handled by the DC circuit courts with respect to the schools. We might actually call these the segregation cases rather than the desegregation cases. So then, of course, in 1954, the Supreme Court in Brown versus Board of Education strikes down separate but equal under the Equal Protection Clause. But there was a legal problem in that the Equal Protection Clause applies only to states. The 14th Amendment says no state shall deny to any person within its jurisdiction the equal protection of the laws. And that doesn't apply to the district, which is not a state. So the Supreme Court in Bolling versus Sharpe holds that the Due Process Clause of the 5th Amendment, which does apply to the district, incorporates the Equal Protection Clause, and that segregation in public education is an arbitrary deprivation of liberty in violation of the Due Process Clause. It would be unthinkable, said the Supreme Court, that the same Constitution that prohibits the states from maintaining racially segregated public schools would impose a lesser duty on the federal government. So that's what gives rise to the next category of public school cases the DC Circuit Courts have been involved in, and that's what we might call implementation of the Supreme Court's desegregation mandate. And here the leading case is Hobson versus Hansen. So a week after Bolling versus Sharpe, the DC public schools announced their intention to comply with the Supreme Court's order. unlike in some school systems, there was no massive resistance to the prospect of school desegregation. But at the same time, the school system did not, shall we say, embrace the prospect of integration, true integration, with open arms. So, for example, for a while it permitted white children to get out of going to integrated schools and to transfer to schools that were basically all white because of neighborhood location, if the white children simply demonstrated some kind of psychological upset at the prospect of attending an integrated school. The school system also created certain kinds of what it called optional zones that permitted children in that zone to attend either of two schools, one of which was located near public housing and public transportation and was predominantly black, and the other of which was located in a wealthier neighborhood, largely accessible by car, and was predominantly white. You can imagine the segregative effect these optional zones had. And then famously, the school system created a rigid tracking program where children were assigned to, in the early grades, to one of four tracks, ranging from the euphemistically named special academic at the bottom to honors at the top. And in principle, there was supposed to be some movement among the tracks over the course of a child's life, and even over the course of different courses for any individual child over the course of the school year. But in practice, a track was pretty much fixed from day one, and the distribution of children into these tracks correlated pretty tightly with neighborhood median income and with race. So, in 1967, in Hobson versus Hansen, Judge Skelly Wright, writing for the district court here in DC, struck these practices down, again under the Equal Protection Clause component of the Due Process Clause that the Supreme Court had identified in Bolling. As an aside, why was Judge Wright, who was a member of the Circuit Court of Appeals, deciding this case in the district court? Well, remember that the judges on the district court were tasked with appointing members of the Board of Education. So there was a perceived conflict in the regular district court judges assessing the constitutionality of the Board of Education's decisions. So in any event, Judge Wright held unconstitutional quite a number of policies and practices of the school system, and he ordered a lot of changes. He ordered the abolition of these tracking policies. He ordered the school system to come up with a new student assignment plan that would maximize integration. He ordered busing on a voluntary basis for children from overcrowded schools east of Rock Creek Park, that is, effectively black schools, to underpopulated schools west of Rock Creek Park, that is, effectively white schools. And he ordered what he called immediate substantial integration of teachers at racially segregated schools and the presentation of a plan to fully integrate the teaching staff. So that was 1967. In 1970, parents came back to court to try to stop a couple of the Board of Education's redistricting decisions on the grounds that they would thwart integration efforts. And Judge Wright ordered that the board, in some instances, stop, and in other instances, reconsider some of its decisions. And then shortly after that, in 1971, Judge Wright issued a new decision finding continuing substantial discrimination in resource distribution between schools that were still either substantially white or substantially black, and ordering rough equality. And the Board of Education declined to appeal these various decisions. So this is the second category of DC federal court involvement in the DC schools, the implementation of school desegregation. So the third category turns to special education for children with disabilities. Now, you may all have heard something about the primary federal statute today that creates a right to education for children with disabilities, the Individuals with Disabilities Education Act, or the IDEA. You may not know that the procedural and substantive rights set forth in that statute are modeled after the procedural and substantive rights provided in the remedial decision of a 1972 case called Mills versus the Board of Education of the District of Columbia. So in Mills, the parents of 7 children, 7 different families with children with disabilities, brought a class action to require the DC public schools to admit them and educate them, rather than keeping them out of the schools entirely or refusing to teach them after they were admitted. At the time of the lawsuit, there were an estimated 22,000 school-aged children with disabilities in D.C., and somewhere between 12,000 and 18,000 were not being served at all or were being served in no way calculated to meet their needs. Now, the school system admitted that it had a legal obligation to serve these children and admitted that they were not doing so. So the real dispute was about the remedy. The school system said that it was impossible to provide the relief the plaintiffs wanted unless Congress appropriated millions of extra dollars for special education in D.C., or unless the district itself diverted millions of dollars from the existing education budget, which the district then said would be unfair to children outside the plaintiff class. Now, the court rejected this protest. The court said that whatever funds were available had to be, I'm quoting here, expended equitably in such a manner that no child is entirely excluded from a publicly supported education consistent with his needs and ability to benefit therefrom. And the court then ordered that the district provide to each child of school age a free and suitable, I'm quoting again, publicly supported education regardless of the degree of the child's mental, physical, or emotional disturbance or impairment. Those are the substantive protections. And it also required a series of procedural protections for students in their initial education placements, in any subsequent change to those placements, and in any disciplinary hearings. So as I just mentioned, that framework from Mills became the basis for federal law, the IDEA, that Congress passed in 1975. Now, fast forward 22 years later to 1997, when two different groups of plaintiffs filed class actions against the district, alleging both that the district was failing to hold timely administrative hearings and issue hearing officer determinations under the IDEA, and also that those decisions and settlement agreements were not being implemented, either at all or in a timely fashion. These cases were eventually consolidated as the Blackmun-Jones litigation, and thus began the second chapter in federal court involvement in special education in the district. Now, this case is still ongoing, so we are not going to say too much about it here, other than just to note there are almost 3,000 docket entries in the case, which should just give you a sense of the scope and longevity of the decision. The parties for years have been operating under a consent decree overseen by a court-appointed monitor. But again, we're not talking about pending litigation today. There have also been some other special education class actions during this time, one about special education services for incarcerated youth, one about providing transportation services and provider payments for children with disabilities, and another about identifying and then serving preschool children with disabilities. So that's the third category of federal court involvement in the schools in D.C., the special education cases. Now, the fourth category of case are kind of a mishmash. There are other class actions seeking to effect major structural change outside the context of desegregation or special education. So again, there's a pending case in this regard about school closures that we're not going to talk about, but there have been other cases in this category in recent or historical memory. For example, in the mid-1990s, there was a case trying to get the district to live up to its obligations under the federal grant program, providing services for children with homeless children. Also in the mid-1990s, although perhaps this is cheating for the purposes of our panel on federal court involvement, but there were a couple of cases filed in Superior Court to try to get the district to remedy thousands of fire code violations in the district's public schools. A separate case to get the district to comply with its obligations to provide nurses in the public schools. So again, these are examples of court involvement in major structural change outside the context of desegregation and special education. So the fifth and final category of case I'd call individual or one-off cases, where individual students or parents or teachers file a claim alleging some kind of individual wrong. Often, although not always, it's a challenge under the IDEA to some aspect of the services that the child is being provided in special education. So those are some facts, the description of some ways the courts have been involved. So let me just now say a couple things about different competing narratives we might see these facts in. in connection with the question I began, which is the extent to which the DC Circuit Courts have played a role in ensuring the success of public education in the district. I have 4 different brief narratives that I'll offer, although I'm not claiming that these are all inclusive. So one narrative would say yes, the DC courts, the federal courts have played a positive role in this regard. So let's start by going back to when district court judges appointed members of the Board of Education. Well, from the beginning, they ensured some representation for women and for African Americans on the board. You could say this was a good thing in order to ensure some diversity in decision-making. In the cases and controversies realm, Hobson versus Hansen ended a rigid, racially discriminatory tracking system, tried more generally to get the district to live up to its overall desegregation obligations, and tried to fix the inequitable distribution of funding across schools. Mills and its progeny found a constitutional and a statutory hook to require an education for thousands of the district's most vulnerable students, and then laid the groundwork for the IDEA to do the same thing nationwide. So under this narrative, one might say that the federal courts provide a backstop. When the legislative process is not working, when the political bodies won't do what's right, the judicial process can be valuably invoked. So here's what Judge Wright wrote about this in the main opinion in Hobson. He said, "It would be better far indeed for these great social and political problems to be resolved in the political arena by other branches of government. But these are social and political problems which seem at times to defy such resolution. In such situations, under our system, the judiciary must bear a hand and accept its responsibility to assist in the solution where constitutional rights hang in the balance." I'm going to add statutory obligations to that resounding phrase. I see my students who just took the regulatory state with me this semester. They will understand why, as I hope you will, why I am adding the importance of statutory obligations to this phrase. That's the positive narrative. The counter narrative would say the court's involvement might have been a little more negative than that. So let's go back to Carr versus Corning and the other segregation cases, what I called the segregation cases, not the desegregation cases. So even aside from the court's acceptance of separate but equal as the constitutional order, it's pretty shocking to see the court dismiss vivid evidence of inequality between the black schools and the white schools, which the dissent marches through in painstaking and painful detail. And although the historical instigation for this event is the 60th anniversary of Bolling versus Sharpe in the Supreme Court, as I've said, in the DC federal courts, the case didn't do much, anything, in the way of promoting the success of DC public schools in that case. So under that narrative, to go back to Judge Wright's frame that I just read, you can ask the judiciary to accept the responsibility of assisting in a solution, but you're not always going to win. Even after the Supreme Court reversed the lower court decision in Bolling, it's not as though all members of the court embraced it with open arms. So to the contrary, there's some compelling evidence that the judges of the DC Circuit Court, of the district court rather, refused to reappoint members of the Board of Education who were strong desegregation advocates. And the judges also kept strict black and white quotas on their appointments to the board, even as demographics in the city and the school district shifted to become more and more majority black. Under this more negative narrative of court involvement, even Hobson versus Hansen can be read in a slightly different light. So the court based some of its findings, leading it to strike down the tracking program, on the problem of what it called low self-esteem, linked to, and I quote, "the traumas suffered simply because of being Negro." And the court also seemed to endorse its limited busing plan, in part because white children would remain in the majority in their schools. Okay, the third narrative suggests that there are institutional competence limitations on what courts can do to promote success in the schools. So just as one example of these limits, contrast these two judicial statements. Here's the Corning dissent, which would have struck down the district's segregated school system as unconstitutional back in 1950, before Brown and Bolling. The dissent wrote, "It is sometimes suggested that due process of law cannot require what law cannot enforce. No such suggestion is relevant here. When United States courts order integration of District of Columbia schools, they will be integrated." And here's Judge Wright in one of the Hobson opinions 20 years later. Neither this court nor the school board can do anything, of course, to eliminate segregation, which arises from the migration of white children to private or suburban schools. So the Hobson opinions may have been ambitious in a lot of ways, but in this acknowledgement of some institutional competence limitations on the court in effecting change in the schools, Judge Wright may have grasped an important reality. Now, the last narrative I'll mention questions the court's relevance in promoting success in the district schools at all. So a lot of important changes in the governance of the district schools have come entirely outside the process of judicial involvement. Major education reforms in 1995 with the creation of charter schools in the district, in 2007 with the move to mayoral control of the schools, were the product of legislation, not litigation. And so, for that matter, was the 1968 act that finally got rid of the process of judicial selection of the members of the Board of Education after a lawsuit had failed to have the process declared unconstitutional. The U.S. today, the U.S. Department of Education is another external, non-judicial source of control, including the Office for Civil Rights, which oversees compliance with various anti-discrimination laws. And the U.S. Department of Education is also home to a series of grant offices that oversee millions of dollars in grant money under the IDEA, under No Child Left Behind, under Race to the Top here in the district, obviously as well as elsewhere. Then there are local policies and programs, such as the multi-million-dollar facilities upgrades going on now and the district's major commitment to preschools, which may be its most successful desegregation program yet, all of which have nothing to do with the courts. And then, of course, what happens in the classroom is a critical part of what ensures success in education, and it's a part from which the courts are pretty much absent. So, what should we take from all of this? Have the courts played a role in ensuring success in public education in the district? So we're about to hear from our distinguished panelists on this question. I'm very eager to hear their take. I'll just say my quick take is that yes, but. So yes, because sometimes the judicial backstop really is needed, but it's not always going to work. And sometimes, even if it does, there are limitations on what it can achieve. And there's a lot of important reform work that can't be achieved through litigation at all. If you think of yourself as having a hammer, then everything starts to look like a nail. But the 21st century education lawyer needs to have a much more expansive tool than just the hammer of litigation, which may sometimes be necessary, but which is rarely going to be sufficient. So I'll stop there and turn things over.
Thank you, Professor Pasachoff, for that terrific presentation. My name is Jeff Kleinberg, and I am the chair of the program committee for the D.C. Circuit Historical Society, and I, with Steve Pollack, would like to tell you how very pleased we are that so many of you have been able to join us today. We're now going to move to the panel discussion phase of our program, and I have the honor of thanking and welcoming our moderator for this afternoon. Professor James Forman, Jr. of the Yale Law School teaches and writes in the areas of criminal procedure, criminal law policy, constitutional law, juvenile justice, and of course education law and policy. He also taught for 8 years at the Georgetown Law Center here, and in 1997 he co-founded the renowned Maya Angelou Public Charter School here in the District of Columbia. Professor Forman is currently writing a book about crime and criminal justice policy in Washington, D.C. Please join me in welcoming Professor James Forman as our moderator this afternoon.
Thank you. So we have that was a terrific framing remarks from Eloise, thank you. And we have an amazing panel, as you can see. So I want to get right into it and get our panel going. I do want to say one word of caution. I have to say that the remarks of Chancellor Henderson and those of each of the panelists here are presented in the spirit of learning from history and are not intended to address any issues in pending litigation. Amen. So with that out of the way, I think a good place to start would really be where Eloise left us. She framed a question: have courts played a role in ensuring success in public education in the district? I want to start by broadening that out a little bit to talk about the role of federal courts in ensuring success in public education broadly. And Judge Tatel, I'd like to start with you because in many ways, your career before you joined the bench was predicated on the idea that the answer to that question was yes, or at least had the potential to be yes, that federal courts could play a meaningful role in helping schools become both more equal and more diverse, less segregated, and better. And so I was wondering if you could open this conversation by talking a little bit about what convinced you that the answer to that question was yes? What made you think this was work worth doing?
James, I'll answer that question as best I can, but let me start with just a footnote to Professor Pasachoff's excellent talk. And it's about the 1950 D.C. Circuit decision in Carr. She mentioned that there was a dissent. The dissent was by Judge Edgerton. And I've always been intrigued with the dissent because in support of his conclusion that essentially that segregated schools are inherently unequal, that's essentially what he said, he was clearly foreshadowing Brown. Yet, unlike in Brown, where the court relied on social science evidence, remember famous footnote 11, Judge Edgerton cited nothing. He followed the exact same approach that Justice Harlan did in his dissent in Plessy. Everyone knows, he essentially said, that segregated schools, legally segregated schools, are inherently unequal. I once tried to figure out what role this dissent played in Brown, and I think probably hardly any. It wasn't cited by Brown. Might have been mentioned in the briefs, but only in footnotes. And the lawyers who brought Brown, Charles Hamilton Houston and Thurgood Marshall, and the rest of that group of extraordinary lawyers, were not involved in Carr. It wasn't their case. In fact, at the time, Houston was heading a coalition of D.C. parents who were advocating equalization of schools, not desegregation. So there's another reason, by the way, that I've always been fascinated with the Edgerton dissent, which is personal. In our robing room, we each have a closet for our robe, and they leave the names of the judges on the closet, even when they're passed along to others. And the first name on my closet is Judge Edgerton. So I've always been inspired by Judge Edgerton, and particularly this fascinating dissent that's actually, except for Kluger's equal justice, has had remarkably little attention. So, James, I think I have a pretty short answer to your question about the role of the courts. And I'm going to focus on the role of the courts nationally, not in the district. Professor Pasachoff has dealt with that more thoroughly than I ever could. And I'll just say one or two things about that. First, once the Supreme Court made clear in the early 1970s that desegregation meant desegregation, that it meant, as the court put it, the elimination of all vestiges of the former dual system now. Once the court made that clear, and once once the executive branch became enlisted in the effort, and once Congress became involved through the passage of the Civil Rights Act of 1964, and once the court extended the desegregation principles beyond the South. Once all that happened, which all occurred in the 60s and early 70s, once that happened, the federal courts had a dramatic effect on desegregation throughout the country, on desegregating the nation's schools. It was dramatic. It may have been, I'm not sure about this, but one of the most dramatic impacts the federal courts have ever had on a social institution. So what about today? A month ago, maybe a month ago, there was another report analyzing racial composition of the nation's schools, showing that the schools look pretty much just as segregated now as they did then. That is before Brown. Most minority, according to the latest report, most minority children in the public schools go to overwhelmingly minority and overwhelmingly poor schools. So, are the schools still segregated? Well, they're not in a legal sense. Sure, I have no doubt that there are still vestiges of the former dual system in some school systems, and there are courts and lawyers who are focusing on those. But I think most people would agree that nationally, the quote segregation, and I put it in quotes because it's a different kind of segregation than the courts were dealing with, that the segregation, the racial isolation that exists in our schools does not result from state action and cannot be dealt with by the federal courts. The federal courts are not, I think, largely a tool that can be used for dealing with this issue. This is, in my judgment, largely a question that is the problem of overwhelmingly minority and overwhelmingly poor urban schools is largely the challenge that our chancellor is facing. That's her job. I don't think the federal courts and chancellors and superintendents like Chancellor Henderson throughout the country. This is the school reform movement, and this is their task. And I think, except maybe around the edges, at least nationally, I think the federal courts have a very remote role in this effort.
Thank you, and we'll circle back to both some of those questions of integration and that Judge Tatel raised. Rod Boggs, I want to go to you again for a little bit backward looking, a little bit of the historical perspective from where you sit, because you and your organization were involved in various pieces of litigation as well as other advocacy, and I was just wondering, as you think about Eloise's question and you think about what you've seen here in the district, what role, how would you assess the role that federal courts have or have not played in ensuring quality education here in D.C.?
Yeah, thank you, James. I think it's interesting. I mean, the law of unintended consequences to some extent has played itself out in the district in particular, where we are limited in the reach of the federal courts to mandate the type of integration that would have been true in many other districts after Brown. And what I was struck by, even to be remembered myself, remembering that the Lawyers Committee, the Washington Lawyers Committee, really began to get involved in these issues actively around 1979 with the support of the then superintendent of schools, Vincent Reed. But what I, of course, remembered the Hobson case. I knew Julius Hobson actually quite well. But when you look at the Hobson cases, and what many of you in the audience may know, but probably many of you don't, I mean, if you look at what happened to the enrollment in the D.C. public schools in the years between Brown and Hobson, you had really a significant decline from 1954 to 1966 in the percentage of white enrollment in the school system, from 42% white down to 9%. But then in the period that followed between 1966 and 1979, which was the period when Hobson was being implemented, the white enrollment shrunk to an almost minuscule level of under 4%. That's about the time when my kids were in the school system. So integration, for all intents and purposes, was a non-starter. You had to look in other directions. And the way that the Lawyers Committee, when it began to identify this as a critical issue, which it had not done for the first 10 years or so of its existence, was after speaking to the Chancellor and then the Superintendent, and the answer was, you've got to help the parents in the schools of greatest need. Now, almost all the schools were of great need, because what we quickly found out in studying our school system compared to virtually any other school system in the region is we had the lowest paid teachers, we had the lowest paid principals, we had some of the largest classes, we had the most deplorable conditions in terms of the buildings and facilities, and we hadn't paid attention, obviously, to special ed either. So there was an enormous set of problems, and the way that we intended and decided to address them were through working with a citywide parent organization that fought for several decades just to get the bare minimum of funding to address some of these. And along the way, actually decided to litigate as appropriate in the ways that Professor Pasachoff mentioned, both in terms of providing nursing services, which had been statutorily mandated in 1987 but never provided. Looking at the question of building conditions and deciding the way to attack it was looking at the fact that there were almost 6,000 fire code violations, many of them dangerous, and the buildings were collapsing. Those are the policies. And the other one, which many of you may, if you lived here a long time, would remember, the Lawyers Committee was very active in the legal side in putting on the ballot in the district, and as I mentioned to the professor earlier, in 1986, an initiative to require that education be treated as a matter of highest priority in the city, and there be mandated public hearings where citizens could testify to the Board of Education, the mayor, and the council about the needs of the school system. That was very important in terms of holding the line on where we were headed. But in essence, litigation became an adjunct to a strategy which really was more political and assisting parents. And I can talk later about how it's really evolved into an even, I think, more effective strategy, and one that now has the greatest potential by far in the history of this school system, in my lifetime anyway, because of the presence of a change in governance in the system, which we advocated to give the mayor the authority to appoint the chancellor, and then our good fortune in having the chancellor we have right now.
Great, thank you. Brian, I'd like to bring you in the conversation, and because, Judge Tatel said, in a sense, that for a lot of the issues that we're facing now, there's a limit to what the federal courts are going to be able to do and how they're going to be able to make a difference. And I know that you've worked in different ways. And I guess I think about it a little bit autobiographically. I mean, in the 1990s, I went to work as a summer associate for 2 summers at the NAACP Legal Defense Fund, and they, had this big education docket, but this was by now the 90s, and there was a sort of a staleness to it that I felt, and it felt irrelevant. Not that you couldn't have imagined a world in which court decisions would have been different, such that that wouldn't be true, but the world that they were operating in at that point. And so when I came and was a lawyer here and frustrated with finding no schools for my clients in the juvenile justice system, really almost out of desperation, a charter school seemed like a way to proceed, seemed like maybe but litigation didn't seem like it had, litigation in federal court seemed like it almost had nothing to do with the problems that I was seeing anyway. And so I guess I'd be curious to get your reaction to that, and really you're thinking about the question of, well, if not courts, then what?
That's a great question, James. And I think of this sort of autobiographically as well. I spent 4 years of my career working in federal education policy as the general counsel of the Department of Education. And when I finished up there, the fact of the matter is I feel a passion for education. I know that education is the thing that changes and transforms lives, as everybody here does. But, I'm a resident of Washington, D.C., and what was clear to me was that I wanted to have an impact on the schools in my community. And I think I'm somebody who kind of begins from the premise too that I think federal courts, do have their limits, particularly in this area of the law in particular. To agree with Judge Tatel's point, I mean certainly the federal courts had a significant and an important impact in the desegregation effort. But I think what we find today is, as others on the panel have said, is that the hard work, I think, really comes in how are we going to kind of expand the opportunity of every kid in the city to have access to a high-quality seat, in a school. And the fact of the matter is, I would, with all due respect to some of the people in the room, many of the people in the box behind you, I would take 100 Kaya Hendersons any day of the week over any number of federal judges in terms of the ability to be able to, to really move the needle in terms of what impacts kids and what creates opportunities for kids. So you mentioned the charter sector, and so I got involved in the charter school sector here in Washington. Was appointed to the board that authorizes and oversees all of the charter schools here in D.C. back in 2007, and became the chair of that board in 2010. And one of the things that's been fascinating is to watch the growth of the charter sector here in D.C. Today, charter schools educate about 44% of the public school kids here in the district. And I remember when Chancellor Henderson's predecessor, Michelle Rhee, once had said that. But for the charter sector and its success, she may not have had the job that she had here. And I do think that there has been an important role that the charter sector has played here in innovating, in creating high-quality seats, and in a way creating the conditions upon which the charter sector and the traditional public school sector in DCPS, I think, have really worked together to improve this sector. But what's critically important in that enterprise is having sort of community buy-in, community participation. It's the political support, small p, on the ground that's essential for that kind of improvement. We talk about the challenges of sort of moving the conversation away from desegregation and looking to greater integration. I would argue that the work that Kai has been doing over the last several years is doing more to bring middle-class families back into D.C., and that includes middle-class minority families, middle-class white families, because what they're seeing is that there's energy again in the school system. There's a relentless focus on data and a relentless focus on results. And there's a relentless focus on making sure that we have leadership in schools that sort of bought into that vision. And that, I think, is where Kaya has really made a big difference. And again, as you look at the composition of the school system, the charter schools in the city are schools of choice. Everybody who comes to a charter school chooses to go to that charter school. Charter school admissions are, they're public schools, and they take all comers. If they're oversubscribed, they have to have a lottery for admission. But everybody in those charter schools has made the choice to be there. Today, about 83% of the students in the DC charter schools are African American. You compare that to the DCPS system, where again, many people are choosing to be in that system. Others are being assigned to schools in that system. About 69% African American. The white population in charter schools is about 3% here. It's about 16%. In DCPS. And so I find that that's sort of an interesting dynamic because, you know, again, we may look at that and say, well, gee, the charter sector here looks awfully segregated. But again, that's in the context of a pure choice system. You know, again, the DCPS system is diversifying, I think, very quickly, and in part because of the work that Kai is doing.
Well,
I should say a significant part.
I want to get back to the question about the sort of the integration point that you raise in choice. But so Kai, now we've heard that. So Brian says that he wants 100 of you over these. No, really.
With all due respect. With all due respect.
Some of my best friends are federal judges.
Not me, right?
So I guess, though, there seems to be a consensus forming that this notion of the sort of, you know, where the action is outside of courts. Maybe there was a moment where they played a role. Now, not much. But then Eloise holds out this notion of kind of backstop, the idea that, well, maybe as a backstop, we want to have these courts for, I don't know, we need to figure out what they're supposed to be backstopping. But I guess I would ask you, from where you sit, do you, I mean, obviously, given the career choices you've made a set of decisions about where you could have the most impact. But what about this notion of federal courts playing a role, a backstop role, and what might that look like to be helpful?
So I actually do. I'm sort of a both and kind of person, and I do think that there are a couple of important roles for the federal courts to play in all of this. In part born out of my autobiographical experience. So I'm a little black girl who grew up in the 70s, who went to an integrated elementary school on the south side of town, or the African-American side of town. My family, who lived in the projects, we walked to school until I got into the 4th grade, when it was determined, and they bused the white kids into the African-American community as part of the desegregation case that the district was under, until 1978, when they decided, no, they didn't have to do that anymore. They would bus the black kids over to the white side of town. And so they picked my school up and moved it to the white side of town and bused the black kids the other direction. And that was very interesting to me. I also grew up in a family where we talked about things like Brown and what it meant for us. That in fact, the court had said, the court had the final word around segregation. And I do think that still, in cases where there are disputes between people and the government, the court's role is to interpret the law and have the final say effectively. And so I think it's very important for the citizenry, when they have a dispute with the government, being public schools or what have you, to be able to go to the court for a final word. That being said, I think that the challenges around implementation are very significant, and I think then limit the effectiveness sometimes of that final decision. I think the professor called it institutional competence limitations, right? And that could vary from the capacity of the institution, frankly, to the resources at the institution's disposal, to literally just the conflict against other rules and regulations that the institution has to abide by, that when taken all together create conflict, right? When I think about DC Public Schools, when I came to DC Public Schools, we were in the midst of 4 court orders. And to be honest, I could not understand why we hadn't had more progress on some of them, because in my mind, when the court says you have to do something, you have to do something. And for years, we had not met the requirements that the court set out for us. And I'm pleased to say that's no longer the case. But I also know that part of that is because, to be frank, there were no consequences. Who do you hold responsible when you have a 9-person elected school board to ensure that you have the resources as a superintendent to carry out the things that you need to do? And in fact, I think this is why the shift to mayoral control is very important, because there is a more accountable, at least, actor that you can hold responsible. Sometimes I get a little feisty. I'm watching my friends in LA, Vergara just happened, right? And I'm like, Rod, can we sue about, right? It's like, some of what we've learned, right or wrong, some of what we've learned is, in fact, we overburden ourselves when we, get these mandates from the court. And I happened to sit on a panel with Randy Weingarten, the head of the AFT, 2 days ago, and we were discussing the Vergara case. And one of the things that was interesting to me is the very same things that they had to sue to get in LA, we actually negotiated here in DC. And so generally, I think implementation is easier and more likely to be successful when you're able to negotiate those kinds of things versus when the court has to instruct you to do things. And so, I come to this as a layperson. I got my legal degree from Law and Order, right? But I do know that political will is important. And I think we've seen a realignment of political will around education in Washington that has paved the way for people like me to do my work. I appreciate the kudos, but I think I just got here at the right time when the stars were aligned and people were so fed up with the lack of performance of the school district that lots of things happened, from legislative things to financial support to what have you. But I do still believe that, I believe fundamentally that the closer things are to the ground, the easier they are to get worked out. But still, when you can't work them out, somebody needs to be the final arbiter.
So I want to shift and talk a little bit about a question that has now come up. A number of you have raised this question of integration. And it's a challenging one because obviously historically it's been closely connected to what we've just been talking about, which is the role of federal courts. But it doesn't have to be. And as Judge Tatel said, it really in many ways can't be anymore. And so I want to have y'all weigh in on this challenge, which is that there's one of the striking features of kind of educational reform discussions today versus 20 years ago or 30 years ago isn't just that, well, we're looking to community action and legislation and excellent chancellors and charter schools. It's that we've really stopped talking about integration as a goal. And that makes me sad. I'll just put mine out there. And I want to know whether you share any of that, whether this is something that we have appropriately, stopped talking about and taken off the agenda, or is it the sort of thing that, well, it would be nice, but there's a lot of things that would be nice, and it's like it's sort of number 30 on the list, and we got to focus on, what's at the top. Because it seems to me that there would be ways to help schools become more integrated outside of federal courts, with federal courts having nothing to do with that. But because it's not even part of the conversation, because it's on nobody's priority list or on very few people's priority lists, and maybe because it's inconsistent with some other things that people think is at the top of their list, it's not really something that there's a lot of intellectual energy, there's not a lot of emotional energy. We've just, in some ways, become satisfied as a society with the idea that we are going to have schools that are de facto segregated, and our entire conversation is about how do we make those schools that poor kids and minority kids go to better. But that has become the whole conversation, and I think that's a problem. So with that, agree, disagree?
Well, I can pitch, and I think it's a noble goal, and certainly one that, as a civil rights matter, we should ascribe to and actually try to implement. But it's really not a very practical thing to think about when you have such a small percentage, in the teens at best, of white children in the school system, and maybe a slightly higher percentage of Hispanic children. You have to get more people of diverse backgrounds and races in the school system, and then try to put things in place which, to some extent, exist already in terms of specialized schools, the ultimate changing of boundary patterns to encourage integration, which is something, again, that the school system is, I really think, paying very close attention to. But, and Kaya can speak to this more than I. I think the fundamental point is, if you go any place in the city and ask people what their fundamental desire is, it's a good school for their children in place, if they can get it. And if it means going to a charter to get a good school, of course they'll go there, and they have the right to do that. But I don't think there's a driving force at this moment for integration to supersede the other goals.
Can I put on my national hat again for a second here? I've been out of this from a policy point of view for over 20 years. So basically, most of what I know about this issue comes from reading the paper, talking to my wife, and the experience of our grandchildren. I think, James, you need to separate the national debate from the local debate. Nationally, you're absolutely right.
Right.
There's no interest in integration, desegregation of any kind that I know of. National political leaders don't talk about it. There are hardly any programs even focused on it anymore. But at the local level, we have grandchildren in 3 school systems, 2 of which were once under court order and no longer are, and 1 of which never was. And those school systems are constant. Now, they don't face the problem that the district does. They have a more diverse student body, but these school systems are on their own, constantly balancing and adjusting attendance areas and deploying schools in a way that promotes many goals, including integration. And they're doing it at the local level without a lot of controversy, it seems to me, and actually, in all 3 of these school systems, quite successfully. Now, as I said, that doesn't help here in the district, except maybe in parts of the district it might. But I think the legacy of Brown and its basic value that integrated education is better than non-integrated education. I think those values are alive and well in many school systems where promoting integration remains practical and achievable. So,
Brian, you want to jump in?
Yeah, I mean, I think I agree with Rod's point here. I mean, again, taking it back to the local level, here in D.C., I mean, our principal challenge is, and this is something that the Deputy Mayor's office studied a couple of years ago. It is quite clear that we have a real dearth, as I said earlier, of access to high quality school seats for kids in the city. I mean, and particularly when you look east of the river, I mean, the challenge of just access to basic quality is real. And so I do think that, there is a focus on quality. Now, I will say, I mean, my own experience, you know, in talking to families and people in D.C. is, I do think that there is an interest. I mean, again, the point that I talked about earlier, where, you know, we are beginning to see middle-class families moving back into the city because of the perception and the reality that the schools are improving here. And I think part of that is driven by this idea that, you know, being part of a high-quality urban school system has a value, and I think part of that value is the diversity element. It's the racial diversity, it's the economic diversity, and I do think there are an awful lot of people here who care about that. But again, as Rod said, when you just look at the simple demographic realities of who lives in this city, who attends the schools in the city, you know, to put sort of the notion of integration sort of front and center, just it kind of flies in the face of just, you know, the hard numbers. But again, I think if we're willing to do the hard work of improving quality, and again, I think the part of the recipe for that is the work that Kaya does. I think it's continuing to have a strong and vibrant and accountable and transparent charter sector, and also having a, you know, sort of a variety of high quality choices for parents here. I think as you see the quality improve, we'll also then see the demographics change here, and I think most people would agree that that's a good thing.
So I think part of the reason why we don't talk about this, right? We don't, in part because we don't know how to talk about race. We don't have a generosity of spirit enough that when somebody says something, if it gets under your skin the wrong way, you literally can't hear them. And so we can't have these kinds of community conversations to reason enough together to figure out right answers because of the legacy of, you know, race relations in the country. So we don't talk about that stuff a lot. It manifests itself in these very interesting ways. So we're in the midst of a boundary and feeder pattern overhaul. The boundaries and feeder patterns haven't been touched for the most part since 1968 in Washington. And you can imagine that this is a very different city now than 1968. And as we have been out with the community trying to figure out what the right answer to this very touchy situation is, you have these veiled conversations about neighborhood schools, and everybody wants to have neighborhood schools, and that means very different things to very different people. If you live in a good neighborhood, you want your child to be able to go to school with other people in that good neighborhood. You bought your house in that neighborhood so that your children would be around a certain kind of children. Or if you're in a diverse neighborhood, you bought your house there because you wanted your children to be in that particular area. Or even if you are in a racially isolated area, there are many parents who feel very strongly about giving their young people the kind of cultural support of a neighborhood school, and they want it to be higher quality. But when you really break it down, sometimes it means I want those other children, because we also have a robust out-of-boundary system where children can travel across the city to go to other schools. I want those other children to go to their neighborhood school so that there's more room for people in our neighborhood, right? A lot of times we're no longer talking about racial diversity. We seem to be a little more tolerant of that these days, but economic diversity is a huge issue. There's also a tipping point around diversity. We want some diversity, but not too much diversity, because if it hits a certain threshold, then it means something different. And as we've gone through this process, it's been wrenching to watch these conversations happen, because for me, a clear intention of the process was to ensure greater integration from an educational perspective. When you look at the fastest strategies to improve your lowest performing students, the poorest students, the students who have been misserved, the quickest thing that you could do, besides give them a high-performing teacher, is put them in an environment with higher-performing students. Right. Children rise to the expectations that you set, and teachers generally set higher expectations for wealthier children. But when poor children are in those situations, they rise to the same expectations. And so when we see that kind of integration, we see poor, struggling, kids who are behind move way fast, right? So as the person charged with turning this district around, I'm good with whatever the right strategy is for doing that. And if integration is it, let's go, besides what I personally believe. But, you know, we also have the legacy of history here in Washington, where before integration, Washington, D.C. was one of the best places for African Americans to get an amazing education, right? Dunbar Senior High School is the first high school for African Americans. And in fact, the issue was not around the student body, integration vis-a-vis the student body. The issue was around the fact that because these African American adults, many with multiple degrees, couldn't get jobs in other places, the best they could do was teach. And so Dunbar had, you know, people with PhDs on the teaching staff, right? And if we know that the caliber of your teacher is the thing that drives student achievement, we had some of the highest caliber teachers in the African American community teaching in schools in Washington, in part because they couldn't get jobs other places. And we see the same thing playing out, right? As minority students in college get opportunities to do lots of things they don't teach. And so you have a tradition of citizens here who were educated in that system and who in fact are sort of in the equalization as opposed to integration camp, and want to kind of reignite that historical perspective. And so it's a complicated conversation. The committee has just made a set of recommendations where they've tried to really balance, I think, in a very thoughtful way, people's desire to be in neighborhoods with our collective desire to be able to have some integration for those folks who choose it. So we'll see how things turn out.
You know, there's another point related to that, James. I think Kaya hit it in terms of how complicated this is, but I would commend everybody here a report that actually was published a few years ago, just before the change in governance, called Separate and Unequal. It's a report we wrote on the state of the D.C. public schools 50 years after Bolling. And what it pointed out is really picking up on what Kaya said. If you looked at the D.C. public school systems in an era of segregation, the conditions under which African-American children were going to school was actually many, many times better than they were going to school in 2005, despite all the efforts in integration. The teachers were better. They were better paid comparatively. The buildings were in better shape. The course offerings were incredibly different and better, and the performance of the children was much better. We lost enormous ground in that 50 years, and I think the reason that the changes occurred, which I mentioned earlier, there are lots of factors in it, and perhaps at some level charters played some role in terms of innovation, but the real driving force was a change in governance and making this truly the priority that the initiative I talked about earlier was supposed to do, but couldn't do it without political will. The political will was demonstrated when now a succession of mayors have made this something they're willing to stand behind and campaign on. And the real issue for our city, which I hope the answer will be yes, is will whoever gets elected mayor this year, be someone who will carry forward with that commitment. Some announcements we've heard from some of the candidates about the person they'd like to see as chancellor maybe will be an indication of that. But the other thing I would say, if you look back at Skelly Wright's decision and at Hobson v. Hansen, you realize that by that point integration had become not particularly realistic just because of the flight of white students. He was really talking about mainly trying to give children in these overcrowded, primarily African-American schools, largely in poorer neighborhoods, an opportunity to go someplace else. Now, it might have led to some level of integration, but it was really to improve their opportunities. And I think one of the things when you look at what we've got now in the system, and this isn't really the primary topic for debate or discussion here, but the fact is that if you look at the kids in our school system, there's about 25% who are in charters or in the regular schools who are in schools still of great need. They're not being well served at this moment as well as we'd like by either category. And the real challenge, I think, for the Lawyers Committee addressing this and for our city is how do we address that in terms of the most children of greatest need, whether we try to integrate them or improve their schools in place. That is our biggest priority, I would say.
So here's how we're going to proceed. Brian on the queue. This event is scheduled to end at 6. I think that we're going to end on time. Chancellor Henderson has a district full of children to educate. Your moderator has a plane to catch. And
they turn the air conditioning off at 6.
Huh. That's the real reason.
And there was a reception that will follow. But I want to, Brian, I want to get you, I had your hand up.
Yeah, but it was really just sort of a quick follow-up on Kaya's observations about some of the conversations, as we think about the new boundaries and that sort of thing. I mean, I do think, though, that still one of the challenges, that we face here is, as we've talked about, is that, there's great economic stratification in the city. And unfortunately, where we sort of have this perception is that, it's all about, Wilson High School and, Alice Deal Middle School, and that they're the model. And you look at the schools in Ward 3, and you've got sort of this, this clamor to sort of move into these schools. But again, I think the question for me is, are those conversations that you were talking about, sort of the complexity of these conversations, and I honestly don't know the answer, is the conversation that you're seeing really sort of a veiled notion that, we want to keep those kids east of the river, or is it driven by just this fundamental, perception of scarcity that we have, and that, gee, I'm in Ward 3, we got great schools in Ward 3, but you know what? There are all these people from all over the city trying to crowd into our schools, and so you go, Kaya, and fix the problems elsewhere and keep those kids out of our school. And is that, so what's behind that conversation?
So
I think conversation, is that an economic conversation?
I actually think it's both, because we serve a broad diversity of constituents, right? And for some, it is the former, and for some, it's the latter. I'll actually point to the charter sector, right? And say, when I look at, we see a lot of middle-class parents now choosing the charter sector, choosing a subset of schools in the charter sector. And their primary driver is diversity. Yeah. They don't want to be in segregated schools. People move into urban environments because they want their children to be able to experience lots of different folks. And to the extent that because of housing patterns or whatever else, we can't unlock that diversity in other places, what better place than a brand new school starting from scratch, which has a commitment to diversity and says we are explicitly going to get X% of this and Y% of that and the other percent of the other, which I can't exactly say, right? And so we are seeing many middle-class parents flock to, the reason why people are flocking to Wilson and Deal is not even necessarily because they're such great schools. In fact, we have lots of other schools that do better for kids than Wilson and Deal, but they represent the melting pot or the salad bowl or whatever metaphor you like, where you have, what people say to me about Wilson is, my kids have friends from Northeast and Southeast. They have friends who are Somalian and Salvadoran, and it's just so wonderful. And so I do think that there are lots of people in pursuit of integration, but how you get from the current system that we have, which is neighborhood-based, and housing determines it, and economics drive housing, to these other models is difficult in an existing structure. And so what we're able to see is more of the priorities around integration being worked out in some of the newer, more flexible places. I do have the ability to close schools and reopen them. We see how exciting that is, right? But I do think that there are a lot of people pursuing diversity as an end in and of itself. But there are also people who are like, look, I finally brought my kid back to D.C. public schools because it's doing okay. I bought my house here. I paid X amount of dollars. And I want neighborhood kids in my neighborhood schools.
I want to know if any of the panelists have any kind of final comments or final observations on the conversation, or anything you'd like the audience in particular to take away. Judge Tatel?
No, I thought that Kaya Henderson's last word should be the last word. That's what I thought.
Thank you. Join me.
We have a reception in the hall outside, and we invite you all to attend. I want to thank the moderator, James Forman, done a wonderful job. Eloise Pasachoff put the stage in front of us, and the panelists kicked the ball over the goal line. Judge Tatel, Chancellor Henderson, Rod Boggs, Brian Jones. I also want to say that it's just 2 days from Kaya Henderson being 3 years in office. So we want to congratulate her. Longevity is desired. Thanks for coming, everybody, and enjoy our reception out front. Thank you. Thanks to everyone.